next goodwill message will be coming from my Lord Honorable Justice Monica Bonan Dongban Manson, CFR, President Court of Appeal, will be represented by our lead discussant. Please a warm round of applause for him.
Very good morning to all of us. I am here to represent my Lord, the Honorable President of the Court of Appeal, my Lord Bonan Dongban Manson, CFR, JP. My Lord is unavoidably absent from here because he's otherwise engaged in other official duty. My Lord recalls that last year, September, I think 1st to 4th of September last year, in conjunction with the National Assembly, PLAC organized a very robust interactive session to discuss constitutional amendment proposed and electoral law, the amendments which were suggested. My Lord has this to say, that that time he sent a very formidable team to PLAC, led by the presiding justice, Court of Appeal Division, Abuja, my Lord Baka. And on that occasion, myself, my humble self, and my Lord Honorable Justice Mohammed, JCA, we presented the position papers of my Lord, the Honorable President of the Court of Appeal. And my Lord said she can confidently say that you are doing a very good job to deepen electoral jurisprudence in Nigeria. And that on that occasion, laudable suggestions were made at amending the Constitution and the Electoral Act so that we can have a very seamless electoral process in the judiciary. Because many people believe that, well, judiciary is the problem. But we believe that with the amendment proposed, everybody will have his say, and the judiciary will, acting impartially, will decide matters in accordance with the Constitution and the law. My Lord also said that she's glad that you have put up this program today just to present your paper, a review of what happened in 2023 general election, which we no doubt help all and sundry, particularly the stakeholders in the electoral process. My Lord said, it is my prayer that your efforts will not be in vain. I have no doubt in my mind that with the caliber of array of intellectual persons assembled here today, along with the relevant stakeholders, solution will be provided to ameliorate and assuage the various challenges that beset our future democracy. I'm also confident that whatever position paper comes out of this August occasion will provide seamless electoral litigation for future electoral reform, and Nigeria's democracy will be strengthened. I wish all the participants worthy deliberations that will strengthen democracy in our country. Thank you. Good morning.
Thank you very much, my Lord, for those very kind words, and of course, call to action. That was also part of your conversation this morning. I recognize your presence, Engineer Yusuf Yabagi Sani, National Chairman ADP, former Chairman of IPAC. Please a warm round of applause for him. Thank you very much. We'll move on very quickly with the goodwill messages. The next goodwill will be coming from the Chairman, Independent National Electoral Commission. It will be represented this morning by a very distinguished erudite discussant who is going to be playing two roles, just as we said earlier on. Please can we welcome him to deliver the chairman's goodwill at this juncture. It's a warm round of applause for him.
My Lord, Justice Ige retired, the Senate Committee Chairman on INEC, ably represented, ladies and gentlemen, I stand here on behalf of the Chairman, Independent National Electoral Commission, to deliver this goodwill message. The chairman directed me to inform PLAC that the commission appreciates its efforts towards developing the electoral jurisprudence of Nigeria. It is a very welcome development. Chairman recalled that the commission has several occasions with the PLAC towards enhancing the election administration in Nigeria. And he asked me to assure PLAC that the Commission is always ready to continue to partner with PLAC towards making our electoral administration seamless. The Commission also wanted to inform the public that it is doing everything possible to enhance the electoral integrity in Nigeria. Hence, the introduction of card reader machine, beavers, and it is currently understudying the performance of the beavers with a view to improving its performance come 2027. The Commission also is ready for public scrutiny, particularly through election petition, whereby every result will be scrutinized judicially and a judicial pronouncement will be made to that extent. It is very glad, the Commission remarks, that as can be seen from the report, the synopsis of the report, very significant percentage of the petitions succeeded during the 2023 general election. There are maybe so many factors to that as analyzed by the report. However, it goes to show that the election administration in Nigeria has greatly improved, particularly when you look at the number of the difference between in every election between the winner and the runners-up. You see always the difference is very thin. It's not that as bogus as it used to be. So with this remark, I'm directed to assure everybody that the Commission will do its best come 2027 to have a credible, reliable election. Thank you.
Professor Mahmoud Yakubu, Chairman INEC, speaking through Tanimu M. Inua, Senior Advocate of Nigeria, the man in charge of in charge of litigation and prosecution at the Independent National Electoral Commission. Please, another round of applause for him. In all this, strengthening electoral jurisprudence in Nigeria involves quite a few other things. We need to improve the legal framework and, of course, also look at the judicial processes, and then, of course, the institutional processes surrounding elections. These are very key and germane issues to be looked at in the course of analyzing these reports, very properly put together by PLAC. I think PLAC deserves a bigger round of applause for all this that he's doing for Nigeria. Mr. Clement Bankwa and your team, we're excited to be associated with you and this noble job that you're doing. The very next goodwill message, Your Excellencies, very distinguished ladies and gentlemen, will be coming from the EU ambassador to Nigeria and ECOWAS, Ambassador Guiter Minot, who is ably represented here by Ruben Alba Aguilera. These are one round of applause for him as he steps forward for his goodwill. If you clap, you live longer. Maybe you're not aware of that.
Thank you so much. My lords, excellencies, distinguished guests, ladies and gentlemen, allow me to stand on all existing protocol. It's my great pleasure to be with you today at this very important event on the analysis of election petition litigation from the 2023 general election. No one can really deny that the judiciary plays a prominent role in Nigeria's electoral process. This is because it will be impossible to establish an effective democratic process without enshrining the supremacy of the rule of law through the courts. The strength of a nation's democracy largely depends on its judicial system, and therefore the judiciary must uphold its constitutional responsibilities, enhance protection of democratic values and the rule of law. The critical role of the judiciary in Nigeria's democratic process has been confirmed by various judgments with great impact on the country's democratic growth. The courts have, through several groundbreaking decisions, strengthened and deepened democracy in Nigeria. In other words, the role played by the judiciary in the electoral process has no doubt given rise to positive and crucial transformation in the development process of Nigeria. But we still have a lot to work on. It is also equally important to note that an effective judicial system is a collective responsibility. While the judiciary has a significant role to play in ensuring a timely, efficient, and transparent dispensation of justice, citizens must also remain informed of their rights as enshrined by the Constitution. And this is also to hold the system accountable. With electoral jurisprudence, there needs to be an adequate information that fosters that compliance with the spirit of the legislation, so that cases are not just dismissed based only on technicalities. The conflicting decisions in respect of the same set of facts is also weighing heavily on the quality of the country's democratic experience and on the trust of voters. And as it was mentioned before, leaders should not be elected through the ballot. The leaders should be elected through the ballot and not by the courts. This phenomenon undermines INEC's ability to conduct well-organized elections due to the logistical challenges that last-minute and oftentimes contradictory decisions of courts pose to election administration, making the exercise of INEC's regulatory responsibilities extremely difficult. There are also, of course, the political tensions that rise with these contradictory decisions, and this contribute to undermine a political climate that does not contribute to stability, to political growth, and the development of the nation. It is also important that a collaborative and multi-stakeholder approach to be adopted, particularly as we move closer to the 2027 general elections. Nigerians must be reassured that the judiciary will continue to uphold the rule of law and that the sanctity of the judiciary in adjudicated cases is preserved. This is why I'm pleased that the launch of today's report will contribute to the work in this area and to provide empirical data and information that both the judiciary and the public can draw on. We hope that the recommendation on this analysis will be considered in the ongoing constitutional review process, so that a robust reform of the country electoral process is undertaken. The European Union has been supporting Nigeria's electoral process in the return of democratic rule, or support to the judiciary over this period in implementing the Administration of Criminal Justice Act, supporting legal reform, as well as the introduction of a specific practice direction has been significant. The issue for which we are gathered today also offers a good opportunity for our continued collaboration with the judiciary, and this is the main reason we have been supporting this intervention by our colleagues and friends at the Policy and the Legal Advocacy Center, PLAC, and we look forward to continue this engagement in this area. I hope that today's meeting will contribute towards stimulating ongoing conversations. Please be assured that the EU will continue committed to continue supporting a more independent judiciary and an improved electoral process. To conclude, I would like to stress the importance role of the courts in fostering democracy and in promoting the rule of law, and to restate our confidence in the judiciary and the commitment to supporting ongoing intervention in this area. I could not also conclude without thanking the colleagues at PLAC for having gathered us all today. We would like to congratulate particularly the judiciary and also all the critical stakeholders for making this a priority. I thank you very much, and I wish you very successful deliberations. Thank you.
Thank you very much. The EU Ambassador to Nigeria and ECOWAS, speaking through Mr. Ruben Alba Lera. Your Excellencies, distinguished ladies and gentlemen, a very quick welcome for our brother and friend, member House of Representatives and a member of the Electoral Committee Matters, Right Honorable Seka Zua Iotiom. Is a member representing Buruku Federal Constituency, Benue State. Please let's welcome him with a round of applause. Honorable, where are you seated? Thank you very much for joining us, sir. We appreciate it. And moving on very quickly, we need to then listen. I'm going to be inviting back the man at the helm of affairs at PLAC, Mr. Clement Mwango Esquire, for yet a very brief overview of this very important report. Please, a warm welcome for him, please.
Thank you, Andy. I think I just talked to you. I said this means Google Timbers because Robert will be giving us the book review. But we need to thank all those who have spoken at this beginning session, particularly Ruben representing the EU and the ambassador, and to thank the EU especially for all of the support for this particular project and several other supports that the EU has provided. I'll hand back to you so we can invite the SCN to speak.
Thank you very much. You know, in my part of the world, when you do this, it's a cut the yarn. So I thought that was what you meant, but that was the item. Thank you very much. Very quickly, for the book review, distinguished ladies and gentlemen, as a senior advocate of Nigeria that's been saddled with this responsibility, and here we all know what stuff he's made of. And so I'm just going to quickly, for want of time, invite our book reviewer, Robert Emorubero, senior advocate of Nigeria, from managing partner at Summit Law Chambers. Please, a warm round of applause for him.
And thank you very much. May I crave indulgence to stand on protocols already established. Now I must thank Mr. Clement Mwango for giving me the honor and the privilege of being the reviewer of this report, which is a comprehensive catalog or repository of the judgments of the Election Tribunal, the Court of Appeal, and the Supreme Court arising from the 2023 election. The book itself is aptly titled From Ballot to the Courts, Analyses of Election Petition Tribunal. Election Petition Litigation from Nigeria's 2023 comments on them in the light of my experience in election petition litigation. One of the first things that struck me from this book is that the report itself is a product of over 1,700 court records, spanning 82,400
pages. I recall this morning in my interaction with my Lord Honorable Justice Peter Olabisi, that's, my Lord, how do you approach some of these records, voluminous records of appeal that litter the Court of Appeal? How do you approach them? Because at times when I see these records of appeal, as a human being, I am frightened. How am I not expected to read through all of these records? Could a tool be devised? That will enable it easy for the judges to, just press a button and everything inside is revealed to them? But really, we couldn't find an answer to that. And I think that is also part of the biggest problem with election petition litigation. The volume of records that the petitioner has to tender, that even the judges themselves have to wade through. This morning as I was thinking about the word dumping of documents, I just thought that maybe a judge is looking at mountains and mountains of ballot papers, voters' registers, and is wondering, what am I expected to do with all of this volume of documents? They appear to have been dumped on the court. So if they dumped it on me, I'm going to leave them dumped. Nobody has spoken to them. And this statistical number that is in this executive summary of the book clearly illustrates part of the big problems with election petition litigation. Voluminous records. So I now saw another statistical comment from the book, which is that about 73% of petitions were determined by the ability or inability of a petitioner to prove their case with credible and admissible evidence. Then about, let's say roughly 27% of election petitions failed on the basis of issues of jurisdiction and procedure. I will come back to this issue later in the course of my review of the book. But what is very, very significant from this book, what is most enriching from this book, are the cases and judgments analyzed in it. They are quite comprehensive, they are concise, and they capture very, very important issues that arose from the course of election petition litigation after the 2023 general elections. Now, section 1 of this book deals with the facts and figures of the 2023 general election, and there is an overview of cases that succeeded and cases that failed. Now, what is very striking from these statistics is that only 4.8% of cases, election petitions, succeeded both at the election tribunals and on appeal. So we have a case where 95% election petitions failed. That now becomes a critical question. Why did over 95% of election petitions fail? Now the failure rate has been broken into two. There are those that failed because of failure of burden of proof, and then there are those that failed purely on issues of jurisdiction and procedure. I will still touch on this later. But what this percentage brought to my mind was a quotation, I believe, of my Lord, the Honorable Justice Nicky Toby of blessed memories, when he said that the proof of election petition is not like that of an Englishman it's not as easy this is what is not as easy as an Englishman finding coffee on his breakfast table. That is where the phrase election petition is not a key part was derived from. But really, I think the question we should ask ourselves is, why should the proof of election petition be difficult? Why should the burden of proof on the petitioner be so onerous that he simply cannot succeed? He fails 95% of the time. Now, I ask this question because when we look closely at the provisions, Water. Thank you. When we look closely, thank you very much. When we look closely at the provisions of the Electoral Act itself, the entire electoral process, starting from the polling units to the final declaration of the election result itself, is meant to be recorded in forms prescribed by INEC. This is the provision of Section 70 of the Electoral Act itself. So there must be a step-by-step record of the entire electoral process, which means election in Nigeria is a matter of public record. So why should it be difficult for a petitioner to rely on public records in proof of any infraction of the electoral law? Now, this will ultimately lead to the issue of the means of proof of an election petition. There appears to be, from the judicial part of the equation, an over-reliance on oral evidence, an insistence on calling agents, party agents, presiding officers, and other persons who are described as eyewitnesses to prove election petitions. And this is really the real reason why election petitions fail. The insistence that there must be eyewitness accounts of what transpired at the polling units. Notwithstanding the fact that election is a matter of record. It's a matter of record. There is no aspect of this electoral process in which there is no record prescribed by INEC for it. And you can get certified through copies of these election records from INEC. But I will still come back to that issue when I deal with the issue of burden of proof in greater detail. So I think that is that with the statistics, the facts and figure. The next section is section 2 of the book, which deals with a summary of the threats and issues arising from the analysis of the 2023 post-election petition litigations. And the first point I want to deal with, that the book dealt with commendably, is on the issue of winners of election filing cross petition. It's not very, it's not a very significant number of winners who file cross petitions, but I think on the issues of filing of cross petition, there appears to be a unanimity of view of judicial decision that cross petitions are only permitted by the Electoral Act itself. So from that, I will move to the issue of incompetent grounds for filing a petition as articulated in section 2.2 of the book. Now, under the provisions of the Electoral Act, section 134.1, there are 4 grounds upon which an election petition may be filed. And the most contentious of the ground is usually the second ground, which is the ground that an election is invalid or should be declared void on grounds of non-compliance with the provisions of the Electoral Act or for corrupt practices. Now, from what we learned from the case of Ojukwu a long time ago, that you need to adopt the precise language of the Electoral Act in setting out the grounds of the election petition. If you decide to deploy your own language, you may run the risk of having your petition struck out if it reduces or enhances the scope of what has been prescribed by the National Assembly in the provisions of the Electoral Act. But this particular ground, there have been conflicting decisions. Even when you adopt the precise language of the Electoral Act, and your ground of a petition is that the election is invalid by reason of corrupt practices or non-compliance with the provisions of the Act, there are decisions that have come down that is still lumping the grounds together, even though you did not use the word "and." Because the whole issue originally started with using the word "and" instead of "or." So I think this particular provisions requires some form of intervention from the National Assembly in terms of disaggregating both grounds so that these conflicts may be attended to. Now, the final point raised in the book on grounds of election petition is where there is a contention that there are incompatible grounds of an election petition that is relied on by a petitioner. Now, the contention that you have incompatible grounds of an election petition usually occurs or should cover areas where a petitioner in one breath is contending that the entire election is invalid, either by reason of non-compliance or by reason of corrupt practices, and in the self-same breath is seeking to be returned as the winner of an election is contending is invalid or marred by corrupt practices. Generally speaking, this has spelled the death knell for that election petition. But the point I just think I must emphasize here is that elections are conducted on a polling unit by polling unit basis. So it is possible for a petitioner to be contending that the elections in named specified polling units should be invalidated either because of corrupt practices or because of non-compliance. And he should still be able to ask that, well, after you have excised these polling units where these events occurred, I am the winner of the election. So in such a scenario, such a petitioner should not be accused of projecting incompatible grounds of an election of petition. But there are cases where petitions have failed because of that, notwithstanding that the petitioner is not contending that the entire election was marred either by non-compliance or by corrupt practices, but his contention is restricted or limited to specific and specified polling units. Now that is also an area I think that the National Assembly needs to look at for the purposes of amendment. Now the next issue is that of jurisdiction that is considered by the book. And under jurisdiction, the first issue considered is the timeline for filing election petitions. 21 days for filing election petition. But very briefly, the only point I wish to make under this particular timeline for filing election petition is that the 21 days begins to run after the declaration of the results of the election. The day the results are declared is not counted. That was an issue that the Supreme Court settled recently. I cannot immediately remember the precise authority where that point was made. But the point was made very clearly and very lucid that the day an election is declared is not counted. And in making that point, the Supreme Court said, if you file an election petition on the very day the results are declared, that petition is incompetent, because the Constitution says you must file it 21 days after the declaration of the election. Now, I think following from the issue of 21 days is the big problem. The big problem of not differentiating between witnesses whose evidence must be filed along, that is a written deposition, must be filed along with the petition within these 21 days, and witnesses that the petitioner simply has zero control over. Those are witnesses that require subpoena, more specifically INEC witnesses, and also, of course, INEC materials. Now, I want to emphasize that one of the biggest problems that every petitioner faces is the fact that he has almost zero access to INEC materials before he files his petition. INEC has exclusive custody, exclusive control over his materials. And at the same time, the Electoral Act makes INEC a respondent to defend an election petition. I think, frankly, this is an incongruous situation. The position was determined to find a way to eliminate INEC as a respondent to an election petition. Because the moment INEC is made to defend an election petition, it automatically has a vested interest in the failure of that election petition. It has a vested interest in its failure because you've made it a respondent. INEC is the same person who has every single material the petitioner needs to succeed. So this is part of what accounts for this 95% failure rate. I mean, I think that is staggering, because the reason why I consider this statistic staggering is that it is a massive incentive for election rigging. It is a massive incentive to undermine the entire electoral process. That is why I think there was a point in time where these words, go to court, was trending. Go to court because of this failure rate. You are going to fail, just go to court. So I think this is an issue that needs to be looked into very seriously. And of course, the book, sorry. The book dealt with specific cases of Abubakar, Atiku, Peter Obi's case on this issue of witnesses whose evidence are not front-loaded along with the petition within 21 days, that those evidence are absolutely inadmissible and cannot be applied. I think this is one of the key areas that was ably articulated in this book, and it's one of the areas in which there is a recommendation that there needs to be an intervention by the National Assembly on this point. Now, I will move on to the next issue of, still under jurisdiction. Still under issue of jurisdiction. We have the issue of nomination, sponsorship, qualification, and disqualification of candidates. And the book very lucidly brought out the problems generated from these issues of nomination, sponsorship, and qualification as being made issues in an election petition. And the cases used to illustrate this are cases from Imo and cases from Plateau State, which I believe that many people are very familiar with. But my little observation on these cases of Imo, cases from Plateau State, where the issue of nomination, sponsorship, and qualification feature prominently, is to bring in the provisions of the Electoral Act, Section 29, 5, and 6, Section 84, 14, and then Section 285, 14, A, B to C of the Constitution. And that the problem, what led to the problem of these conflicting judgments and decisions of our courts on the issues of nomination, sponsorship, featuring in election matters, is the provisions of Section 29, 5, and 6 of the Constitution itself. Now, when you look at the provisions of these two subsections and you contrast them with the provisions of Section 84, subsection 14 of the Electoral Act, you will notice that Section 84, subsection 14 actually comprehensively dealt with the issue of nomination and sponsorship. Anything that has to do with the selection of a candidate by any party is comprehensively dealt with by that subsection. But you now go back to Section 29.5. Section 29.5 and 6 now introduces the issue of constitutional qualification and makes it litigable by an aspirant in the course of a primary. This is where the whole crisis stems from. The provisions of the Constitution dealing with qualification prescribes these constitutional qualification requirements is to contest the general election itself. It is with regard to contesting the general election. Now, the moment a candidate makes a ground of his election petition qualification and mentions presentation of false certificates to INEC, which is a constitutional requirement to contest an election, and which should ordinarily be a valid ground for questioning an election petition, it has been consistently held to be a pre-election issue under Section 29.5, which ought to be filed within 14 days. Now, the problem with that decision or those decisions is that a person who is not an aspirant of that party cannot ventilate that particular issue. So you see, the candidates of other parties can no longer challenge the candidate who is not qualified to have contested the election because he presented a false certificate. I remember in 2007, the first election petition I did in Kano was based purely on the issue of presentation of false certificate to INEC, and the election petition succeeded, both at the tribunal and at the Court of Appeal. But now, that very issue has now been held to be a pre-election issue under Section 29.5 and 6. So I would strongly suggest that those subsections should be looked at critically with a view of deleting them entirely. They give rise to all of these conflicting judgments we are seeing. So I think that is my intervention on the issue of I'm running up right now. Let me just, I think, round up the issue of burden of proof. And my intervention on the issue of burden of proof is going to be as captured in this. Well, it's not really very. Now, on the question of the burden of proof, the only thing that the book has ably dealt with the issue of burden of proof here and highlighted the problems of the application of Section 137 of the Electoral Act, which is an innovation that has tried to intervene in ameliorating the nature and the standard of the burden of the petition. I recall earlier this morning when I discussed with my Lord, the Honorable Justice Ige, and it gave a most brilliant perspective to the provisions of Section 137 of the Electoral Act. And that perspective really helped in explaining some of the decisions of the Apex Court. And that is that the provisions of Section 37 is designed for a very limited compass. Cases where there is manifest disclosure of non-compliance that requires no explanation. And when read, for example, with the provisions of Section 73, which deals with the prior recording of the serial numbers of sensitive election materials on forms prescribed by INEC. This is an event that occurs before the commencement of the election. It is an event that occurs before the election commences. And it is a fact that ought to be apparent on the face of the form prescribed by INEC before the election itself commences. So it is like a condition precedent to the conduct of the election. Where the foundation, the condition precedent is absent, I mean, that's the end of the election, basically. So these are the kinds of matters that ought easily to be established based on reliance on Section 137 of the Electoral Act. But the application of this Section 137, as illustrated from the book, has shown some conflicting decisions. You have decisions where it has been relied on wholly to even deal with allegations of criminality, even though the provision is limited to non-compliance with the provisions of the Electoral Act. So I will commend PLAC for this wonderful report. It is a veritable resource both for lawyers, judges, and justices, and I have found it most enlightening and extremely very useful even for current cases I'm doing. So I say thank you very much to PLAC and Mr. Clement Towanko. Thank you very much.
Can we please applaud him one more time? Thank you very much indeed for that expose given to us on this very important report that is about to be unveiled and launched. That was quite scholarly done and opens a lot of issues for discussion, but especially around burden of proof. But even then, if you talk about burden of proof, to so very many people it means different things, but the judges will look at it from their perspective. Talking about the two main ways with which they are expected to, the main aspects rather, a legal burden or persuasive burden as they are called, and then of course the evidential burden. Well, I'm not an expert in this field, we'll have the experts talk about them a bit later. But at this point, having listened to the review, I must also mention that as the Leonard Silk, as managing partner at Summit Law Chambers, was also a lead consultant at the Constitution Review of 1999, and would like to appreciate that you've been doing very well with what you've been doing. I'm sure posterity will be very kind to you when these stories are being told. Please let's applaud him one more time. And Mr. Clement, thank you so very much. At this point, we'll do the unveiling of the report, and then of course the launch will follow. I don't know if there will be any brief remarks from you before we do that. Okay, fine. So we're just going to go straight to the unveiling. May I kindly request that we invite some of our leaders here to do us the honor of coming up here for the unveiling. Lord, the rep of the rep of Court of Appeal President, and then of course the EU Ambassador, rep of the NBA President,
in front of my live show.
who just did a review, Emo Boro. I think that's the right pronunciation. Thank you. And please join us, sir. And then, of course, our members of the House of Reps that are here, and the Senate Committee Chairman on INEC, the rep of INEC Chair, please join us, sir. Representative of Tunimo Sani MI, SAN, please join us. We must also bring on the yes, a dear mother from the Supreme Court, please join us. Madam SAN, please join us. The woman in charge of the Supreme Court quarterly report, please just join us, ma'am. And then Mrs. Laomi. Matthew Ayibakuru, please also join us. I think we need to invite the Resident Electoral Commissioner, Benue State, Professor Samigu, please join us, sir. I think we have a few more ladies of note that can join us, so it doesn't become all men's affair. Maodi, please, Maodi, please join us. Okay, Madam Enobi, please join us. Please, a round of applause. I didn't know you're in the hall. I usually identify you with your afro hair, and that's what she still has, and that has become your identity of some sort. Okay, let me also invite and recognize Dr. Jacob Bele, TAF Africa. Please join us. Mr. Lanre Arogo Dadi in the National Press Center, Lagos. Please join us. And then Dr. Akimbulu, Center for Media and Society. Please join us as well. Now, what we do is that we might have to climb to the stage proper. It will take many more of you, but that will be done after the unveiling. We'll unveil, and each of you is expected to pick a copy of this report. It's not yet your report. So the moment we are done with the pictures, you're expected to return them, except that Mr. Clement Nanko directs otherwise. So please, Mr. Yabaki Sani, please, former IPAC, yes, he was a presidential candidate in, I think, two different general elections. So can we step forward? INEC chair is already there, my lord, the rep of the president of Court of Appeal.
Yes, we do have the report here, Your Excellency. Thank you. Yes, and His Lordship, the Parliament Court of Appeal. Where's Laulu? Laulu or Laumi, please, we need you here. Come and light up this stage. Yeah, go ahead. Okay, so we'll invite Laulu, Father Barkindo as well. Please. So we'll join His Excellency.
Mr. Meko Menamadu. Yes, sir.
Father Barkindo, you're far away. Laulu, we won't cut until you are here. Laulu, please, let's hold on. Laulu is coming.
Don't wait for Laulu to come this way.
Job with black and white if Laulu doesn't show up. Okay, so His Excellency, the Ambassador, the Deputy Ambassador of the EU will be cutting this ribbon, assisted by His Lordship. Thank you.
Please join us. Thank you.
All right. So we have copies of the report. These reports are available, physical copies here. Normally it would be that we'll ask you to indicate how much you're launching this year. But yeah, it's available free. What is most important actually is that there are a lot more resources on the website that we have created for this. All the cases that were analyzed are online. And I think that if we're looking towards the next elections, lawyers will find that they do not need to be looking for law reports. And judges themselves will see how particular issues were resolved. So these are all available. We'll urge or ask that all of our dignitaries who are here take a copy, maybe more, if they want.
It's okay, Banusa.
But yeah, we have
Prof. Professor Okebanu, please join us, sir. Please join us, sir.
Professor Okebanu is a former National Commissioner in charge of operations in INEC. Professor Okebanu, we are delighted that you're here.
You should come back. He's blocking you.
All right. I'm not sure the cameras will be able to capture everyone in the manner we are standing. I think a few of us can still go up, and please don't allow this to cover your faces, but you can hold it to your chest, meaning that you treasure the report, and it will be of great value to you, and of course to the legal jurisprudence as well as election matters in Nigeria. And we present these to the glory of God and to the benefit of mankind, and especially Nigerians. A round of applause, please. Thank you very much. Mr. Ketmanko, can they go with the copies? Or we wait until when we're done?
It's available.
It's available?
Yeah, let's distribute it.
Okay, they're going to distribute. So if you have your copy, you can afford to go with your copy. Thank you very much. One copy per person. One copy only. Please, just the three of you can hold that. Book reviewer, please join them for just this one. Thank you, sir. Please, one copy per person. They will be given to you, and it will be given to you free of charge. The member House of Reps, you are standing in for your chairman, so you can also join them, sir. NBA President, right. All right. We've also been told that this is available online and on their website, the PLAC website. So feel free to read through. Thank you. INEC Chair, we didn't invite you, please come. INEC Chairman's representative, Mr. Wankosa. Please, let's have you with the INEC Chairman's representative. Okay, please take a copy, sir. INEC Chair. And then you have one copy extra for the INEC Chairman. I'm sure he already has a copy in advance. All right. Thank you very much. The former INEC National Commissioner in charge of education. He do something, come snap with her. I know that you're on this side now. You see things differently, sir. That much I can tell you. I'm being honest with you. Honestly, you see things differently. Professor Eku, do you agree with me that Mr. Festus Okoye is on this side now, and he will see things differently from the way he used to see things? That is what life is all about. Thank you. Thank you very much. We appreciate it. That's your copy, sir. You can live with it. Thank you. All right. Thank you very much. We move on very quickly to constituting the panel, but we need to clear this table. Please clear the table. Thank you very much, sir. table. And then we may bring in the chairs that we're taking.
Yes, he's a compliment.
Right, there's a very short video on the screen. We'd like that played for just a few minutes. And then we invite the persons that are meant to sit on this side of the divide to discuss the perspective on navigating the landscape of elections in Nigeria, litigation in Nigeria, challenges, solutions, and the future of democracy. Only 6 seats, yes, after the video. Can we have an audio on this? We also welcome Mr. Rafsanjani of the Transparency International. Thank you so very much for coming.
Yes, yes, there's a folder.
I don't see it. I don't see
If the audio is not coming, we can quickly set the stage for the conversations that will be taking place. And I think that's the very major thing we have to do next before we bring this event to a close.
You know, I can't come to New York to see you. This is an indictment. The journey is so far.
Willing to be snappy with this, thank you very much. 6 seats and not more than that.
Ah, okay. I'll soon send you.
It won't be necessary anymore, please. Six seats. Thank you very much. First, let me quickly inform you that the discussion is going to be on perspectives of navigating the the landscape of election litigation in Nigeria, challenges, solutions, and the future of our democracy. and you'll all agree with me that election litigation in Nigeria is a vital part of the democratic process. Courts are often seen as the final arbiter of electoral disputes due to some very obvious reasons: contested outcomes from tightly fought elections, allegations of malpractices like vote buying, voter suppression, and result manipulation, public trust in INEC sometimes being shaky, leaving the courts as the last hope, and of course even seeing themselves sometimes playing the role of the electoral umpires in Nigeria. And we also agree with me that over time, election tribunals and courts have played a very key role in shaping electoral behavior, clarifying legal interpretations, and strengthening constitutional principles. These are some of the issues amongst very many that will be discussed. But very quickly, I'd like to invite our lead consultant. Okay, I think he's a lead discussant rather, but I think he just stepped out, so I'll let him be for a few minutes and then invite these following persons who are panelists to please take their seats. First, I'd like to invite Tanimo M. Inoa, SAN, Director, Litigation and Prosecution, Independent National Electoral Commission, INEC. Please, a round of applause for him. I think I should centralize this so it makes it easy. Yes, as a discussant, you can take any other seat, but the middle seat will be left for the moderator, sir. Thank you very much. Okay, our lead discussant just made his way in here, and I'd like that you please join me in welcoming the Lord Honorable Justice Peter Olabisi, retired Justice of the Court of Appeal. Please applause for him as he makes his way here. As our lead discussant, please can I have you sit here, sir? Thank you very much. Yes, sir. Thank you very much. You can sit on that one. Thank you very much. Next will be, to join them on this side, will be Yahya N. Asabi Dangana, SAN, from MICO and Associates. There's a one round of applause for him. To his immediate left. And then I'm going to be inviting Honorable Musa Dachin Bagos. He was a member of the House of Representatives 2019 to 2023, represented Just South and Just East Federal Constituency. A round of applause for him if you intend to make that a clap. Thank you very much. And then, okay, you want to sit there, and I want the NBA president's rep to be there. We want to be able to get the perspectives of the NBA president, who is unavoidably absent, but represented at this occasion. Please, let's welcome the representative of the NBA president as he takes his seat on the side as well. Please, a warm round of applause for him. Barrister, please. Thank you. That last seat. Thank you. And now, to the moderator of this panel. Distinguished ladies and gentlemen, our moderator is Professor Adewale Aderemi, Director, Democracy and Governance, National Institute for Legislative and Democratic Studies, NILS. Please, a warm round of applause for him as he takes his seat. And without much ado, Professor Adewale Aderemi will start by having to provoke our thoughts on this very important topic, perspectives on navigating the landscape of election litigation in Nigeria, looking at the challenges, solutions, and the future of democracy. Please, if your hands are not very busy, can we please applaud him as he takes the stage at this point.
My apologies, I just wanted to give well-deserved recognition to Mrs. Augusta Ogapu, the former Secretary of INEC, who is in the room here and who played a very key role in the putting up of this report. Mrs. Ogapu, thank you so much. Ogapu is a lawyer. She coordinated all of the legal work, all of the lawyers, and gave us exceedingly, if this report is what it is, then please look in her direction. Thank you so much, Mrs. Wonderful. I just needed to make that acknowledgement and recognition. Thank you a lot.
Thank you, sir.
Thank you very much. Professor, it is.
It looks like it's working. Okay. Thanks very much. I think we are already provoked.
I think I am. I thought it was a very good.
Thanks. I thought it was a very good, very comprehensive review that Barrister Emuboro did. I want to compliment you again. And I want to start also by appreciating Clement and PLAC, for giving us this platform, and stimulating us with this publication. Now, some are worried, that election litigation has become a perennial and almost an inevitable part of the electoral cycle. I don't think we should be. I think it's a constitutional provision. What I want this panel to speak to, and what I want us to be more concerned about, are the constitutional and the logistical constraints of that process. One, and to also be concerned about the public perception of the entire process. Whether indeed the law courts are replacing the electorate as the valid, determinant of the outcomes of electoral processes. I thought these two, some of them have been highlighted in the report. The lack of coherence between the ground norm and the Electoral Act, things like that, what I think, we need to really dwell upon. Other aspects of electoral jurisprudence that are concerning to me will be the timeliness. The timeliness of the, I think the statistics for the 2023 general elections were that only 81%, or well, up to 81% of the electoral election panel tribunal, EPTs, open their registries, timelessly. A lot of them, 21% were late in opening the that itself, creates a problem. Then what about the manpower in terms of, deploying justices to these EPTs? Things like that. The lack of access, and I recall a couple of years ago, we are going to leave that question to the INEC, that the INEC chairman was asking for an alternative dispute resolution to managing electoral outcomes. Those are the things I think we need to dwell upon so that we can have an electoral jurisprudence process, that is seen to be fair, accessible, and transparent. And that is what I'm going to be engaging our panels on as we discuss this in the next 1 hour or so. But let me start with our lead discussant, to give us his own perspectives on this publication with regards to the broad topic of the challenges and profiling solutions as we move forward to 2027. My Lord.
Thank you very much, moderator. And I'd like to say a big thank you to my brother, Clement Iwanko, for finding me worthy to lead the discussion. Now straight to business. Everything in this country pertaining to election is governed by law. That is the Constitution and the Electoral Act. These have been like that since the 60s, and it has been specially made a species that is special on its own, that is election petition. It's on a special class of its own. It is not like a civil matter, and it is not like a matter where you just say, I am going to court to go and sue somebody. There is timeline for everything. Let me remind us that way back in 2002, 2003, election petitions were being done for 4 years, uncompleted, 4 years, because of the clamor, because of the public outcry. The Supreme Court led the way by saying that it is unthinkable for somebody to prosecute election petition for 3.5 years, leaving only a balance of 6 months for him to occupy, even if he wins. And that there must be a new reapproachment. And that the time being wasted on election petition should be drastically cut down. And that was why there was amendment in 2011, 2018, and even in 2023 to provide timeline in section 285 of the Constitution. Section 285 of the Constitution has 14 subsections, and they provide for procedure in pre-election and post-election matter. Time within which anybody who's complaining about pre-election matters has 14 days if it is primary election. If it is post-election, that is election proper, you have 21 days. They are contained in section 285 of the Constitution. The same Constitution gave powers to the President of the Court of Appeal to empanel those tribunals that will hear the election at first. Those 3-member panel, she will appoint them and put them in place. We don't need to go to what happened in the registry for now, so that we will have time to discuss the real problem in the electoral process. And we now have Electoral Act that gives us the procedures at election. What will happen if you want to contest election, what you are to do. If you refer to sections 73 down to 84, 85, procedures are laid down there. Section 29 to 32, INEC will call on the parties to get ready for their primaries so that they can produce candidates for the election. That is the procedure. And once they start this primary election, the constitutional provision relating to qualification is also replicated in the Electoral Act. The political parties, they must in their guideline reproduce all the qualifications that a candidate must have into their regulations to guide their primary. All these things are there so that they don't run foul of the constitutional provision and the Electoral Act. But in primary election, many of us know that because the leadership of the political parties, they are not ready to follow their own rules. They are not ready to follow the constitutional provisions, that is procedure for nominating person at primary. They rather want to impose candidates on their party. And that is one of the problems that you have in primary election. You may have election today, primary election in this hall. They will say it will take place in this hall. When you come in the morning, they will tell you it has been shifted to Gariki. Before you get to Gariki, they will call themselves back here. Result will have been written out or something like that. And before you know it, you now have spate of pre-election matters in court. We see it as judges every now and then, shifting of places where the primary ought to be held. Whereas the Electoral Act says that primary for every constituency, whether state constituency, federal constituency, or senatorial district, must be held in the respective constituency. Some will take primary meant to happen in Enugu and bring it to Abuja. So what do you expect the court to do when such matter is brought to court? Of course, the court will cancel and we discountenance that type of pre-election, that election, primary election. And before you know it, they'll be shouting about that it is the court that has imposed candidate. And in a situation like that, the Electoral Act said the party that contravened that section of the law, that's section 84, that party will have no candidate in the election. That is not the court. The court is just to interpret what you have there. If the parties are ready to follow all these procedures, we won't be having all the problem. Then when it comes to election proper, the Constitution had laid it out, the duties of INEC, the duties of political parties, what you should do. That's why you have national legal advisor, state legal advisor, to guide you as to the provisions of the Constitution. So everything you see in the Constitution and the Electoral Act, they are put there to help us to arrive at just decision within reasonable time, as opposed to 2 years, 3 years that we were having in 2003. And when you say procedure for election petition, they've told you, if you look at paragraph 4 to first schedule to the Electoral Act, it tells you what you are to do as a petitioner. It is between you and your lawyer to follow specifically the conditions laid down for presenting your petition. It says, state the name of candidates, state the scores, so that if you say we should return you, we will compare the scores of other contestants and see whether in fact you have made the threshold provided for in the Constitution. But some petitions, they will not state the names of all those who contested, they won't state the name and the scores of political party. They will not state the grounds as required by the law. The thing says, accompany your petition with front-loaded process. That is witness statement on oath, the name or list of your witnesses, whom you intend to call, and all the documents that you intend to rely upon, so that you not be hide and seek. So that when you get to the court will know whether this is a serious petition to be attended to. Those things are there. It has been talked so much that you have problem with witnesses from INEC. With profound respect to all of us. If before you participate in an election, you are supposed to familiarize yourself with the constitutional provision, with the electoral provision, as to how you can fare well in your petition. There is provision in the Electoral Act that says within the 21 days, you can approach the court and say, I want to get some document from INEC. Court, please assist me. I want to use this document to prosecute my petition. The court, of course, the Court of Appeal, we have standing justices who will quickly attend to this and grant the order almost automatically. And if INEC is not giving you the document, there are procedures under Sheriff and Civil Process Act for you to commit officials of INEC for contempt if they will not give you the document. Then the problem with the political parties and contestants themselves, Section 43 of the Electoral Act says you must have polling agents in all the polling units. Tell me, with the greatest respect, how many petitioners, how many political parties engage polling agents during election? Because in those days, even way back in '83, it is the polling agent that will submit results obtained from polling units to their political party headquarters. And before you know it, the lawyers are already working on those papers. They will examine it to see if there is alteration, if there is inflation, if there is deflation, if there is misapplication of vote. It will be clear. But because most of the political parties, they don't make use of their polling agents, they don't even have, many of them don't appoint. And it is when they lose election, that is the time they will be looking for documents. You don't need to look for documents of election, because if you have agents there, Your agent will bring back to you the result of the election, and everything will be given unto you. So it is not the problem of the law. It is not the problem of the court. It is the problem lack of diligence on the part of petitioners. That is what normally brought about all the hues and cries that maybe the court, the INEC, this and that. Then when it comes to onus of proof, I'd like to tell us, since 1965, in the case of Akingide, I think against Akinfosle or so, the Supreme Court has held that election petition is sui generis. It's on a special class of its own. If it is on a special class of its own, it means extraordinary procedure have been set for coming to Election Petition Tribunal and appealing. And you must follow them. Any condition precedent that is missed will be fatal for the petition. And Supreme Court has been saying it consistently since 1965, that it is the duty of lawyer and the client to be well abreast, to be fast in the law regulating cases you want to bring to the court. But many of them, they don't do it. Even in 1983, Ono's case against Nwobodo and Omobori Owo and Ajasin's case, the Supreme Court, relying on Section 149 of the Evidence Act, says that there is presumption of regularity accorded to any result declared by INEC. And it is you who is complaining that the result is false or the story of fault and so on, to approach the court. The onus is first of all on you to show polling unit by polling unit. Some complain only about 4 units, some complain 10 units. Some will say all the polling units across, bandits were involved, armed robbery, this, police, army, not knowing that under Section 135 of the Evidence Act, they must prove it beyond reasonable doubt. If you accuse somebody of criminal activities or allegation, you must prove it, you must identify the person. You must identify the person. Nobody can stand in for anybody accused of crime. Anybody accused of crime will stand in for himself. So it is not a question of, if I don't see the father, I will catch the son. No. If you say Mr. A stole your ballot box, then it is that Mr. A you will prove in the court as having stolen the thing. So by Section 135 of the Evidence Act, in fact from 132 up to 135, that says where in any matter, civil or criminal, an allegation of crime is made against any person, then it must be proved beyond reasonable doubt. So if these things are not left as sentiment, because most of the election petition, with the greatest respect to some petitioners, borders on pure sentiments. They bring sentiment into it, which will cloud their vision to know exactly what to do with their case. It is not the business of the court, who are a court, a judge has sworn, to discharge and to discharge justice or dispense justice without fear or favor, ill will or affection to any person that comes before them. So it is not the business of the court to be part of the crowd or those who are expressing sentiment. The court is to hold the balance, to hold the scale, and give justice to all manner of people according to what their cases and preparation deserves. Those who are talking about Section 137, I spoke with my brother here in the morning, that if you look at Section 137 of the Electoral Act, it's very, very fluid. very cumbersome. If we read it to our hearing, please, moderator, can you permit me to read section 137? Yes, 137. It shall not be necessary for a party who alleges non-compliance with the provision of this act for the conduct of election to call oral evidence, if originals or certified true copies manifestly disclose the non-compliance alleged. In which case, who is he addressing? What are the particulars of what this section is saying? And that was why last year, at another forum, we said that they should knock off this section 137 of the Electoral Act, because it breeds more confusion than reason. And that is why the Supreme Court has now said it firmly that this section, notwithstanding this section, if you make allegation of alteration, of crime, of anything, you must still call witness by witness, your agents who are at the polling unit. Yes. And just like somebody has said, my Lord Nikitobi, in the case of Atiku Abubakar against Yaradua, he said, if you want to prove all these allegations concerning and pertaining to polling units, it is not evidence of a bystander. It is evidence of those who with their two eyes, naked eye, saw what happened at the polling unit. Those are the people who can give evidence of what happened, so that these laws are put in place as a matter of fact to discourage frivolous petitions. And you will see in this part of the climb, we don't like conceding defeat. We want everybody to know that we are the winner. Anybody who's not a winner, then he must rock the boat. So, if and as you make your bed, so you rely on it. If you don't have evidence to support your case, the court is not there to come down from his throne of justice to assist anybody. So what the court is doing is to interpret the Constitution as intended by the National Assembly and to interpret the Electoral Act as intended by the National Assembly. That is the job of the judiciary. And I can say with the greatest respect, judiciary has creditably acquitted themselves well in 2023. Out of 28 governorship something, Court of Appeal set aside 3. When they got to Supreme Court restored the winner. All the winners of 2023 election, governorship, from polling unit, nobody altered or changed by any petition or anything their results. It is those who won at the first ballot that are still governors in the 20th state today. I think I will wait for further action.
Thank you very much. A round of applause from the Lord. Yeah, I've allowed him to, because he's the lead consultant, so I've given him I've been generous with him with time. I am tempted to go straight to MBA, or to Barrister Dangana SAN, just to follow up on what Milord said. He is confident, that the judiciary has acquitted itself very well. When he said that, you see people shaking their heads in the audience. So this is different from public perception. And that's the worry and the problem. So let me go to the MBA rep to address the issue of the contradictions that we have seen, in electoral jurisprudence. Is it the lack of coherence of, the frameworks for election, i.e. the Constitution and the Electoral Act? Or what exactly, because that's the reason people don't accept, that the judiciary has done very well. So what's the position of the MBA? let me pass this to
Hello. Yes. Thank you for having me. I sit to represent the NBA President, Mazi Afamo Sigwe, Senior Advocate of Nigeria, who is unavoidably absent. I want to first of all thank the organizers of this program, the PLAC and the European Union. Our electoral jurisprudence is evolving, and it is the belief of NBA President and indeed all lawyers in Nigeria, including my lord, that the compendium of analysis on election petition litigation, which we have been shared today, will immensely assist our judges and lawyers who are embedded in litigation, election litigations in Nigeria. Now, our election litigation has been characterized with a lot of challenges. Challenges ranging from constitutional impediment and constitutional uncertainties, as well as statutory. When I say statutory, I mean the provisions of the Electoral Act 2022. I must thank God and thank the framers of the 2022 Electoral Act, which is a clear departure, an improvement from what you used to have in 2010. Before now, we used to have deluge of cases, some were longer to 4 years, like my lord had mentioned, but that problem seems to have been solved by the 2022 Electoral Act. But we still have very many issues, uncertainties, challenges with respect to, is it the problem of the law, the Constitution, or the Electoral Act, or just the attitude of political gladiators and actors, politicians who have refused to abide by the rules, to obey the Constitution and obey the law. With respect to the Constitution, proving a case in court at the election petition is cumbersome. It's like trekking from here to London. We must admit that. The experiences we had at the last presidential election, which I participated actively, is something that we need to really re-examine our electoral jurisprudence. The only area I think that's of great importance to us is this issue of burden of proof. I agree with my lord the clear provision of section 137 of the Electoral Act, which is very clear, unambiguous, and unequivocal. We will think and seek to depart or not agree for total jettison of the provisions of the section 137, because there is a remedy of there's a mischief which that section seeks to achieve. But we may be able to interpret it, the judiciary faced with that section, and also faced with the requirement of proof embedded traditionally under section 131 to 135, my lord have said, of the Evidence Act. There should be a way to balance it, because the courts may give out this judgment, but when you go to court of public opinion, when you go to marketplaces, when you go to newspaper stand, social media places, spaces, even in the international community, how do you reconcile the position of the law with the current realities on ground? That somebody will come to a polling unit, hijack the polling ballot box, stuff it, or come there and chase away everybody and all those things. So for the people who participated at the election at the level, polling unit level, they witness what happened. But when the judgment will come out, they will see what the position of the law. They may not know what position, but I know, because I'm a lawyer, my friend here who's a senior advocate knows what the position of the law. So I think the section of section 137 should not be jettisoned completely, but there should be a way we can amend it. We looked at it, we propose, instead of what it is contained, which my lord have read to our greatest audience, it can be amended to say, notwithstanding the provisions of the Evidence Act, I repeat, notwithstanding the provision of the Evidence Act with respect to burden of proof, a party who alleges non-compliance and tenders original or certified true copies of the polling units or ward or local government or state result obtained from either an INEC office or from INEC IREV shall not be required to call other witness polling unit by polling unit, as paragraph 46(4) of the third schedule of the schedule to the letter act shall be given full effect. That is when the documents are taken as read. The problem we have now is the issue of application of the Rules of Evidence Act in Election Petition Tribunal, which seems to put strict proof on the petitioner. How do you, in a presidential election, call witnesses? Because under Section 44, my Lord has said, of the Electoral Act, you have to put your polling unit agent across the 36 states of Nigeria and the FCT. How do you now call witnesses in polling unit by polling unit to prove of a voting or non-compliance under Section 134 of the Electoral Act in case of presidential election? It is practically impossible. You may have to bring deluge trailer, 500 or 1,000 trailer of witnesses from across Nigeria to convert in Abuja. I wouldn't know where they will be lodged to prove of a voting or non-compliance in a presidential election tribunal. So there must be way, the makers of that Section 135, there's a mischief. This is the mischief they tend to cure. The judiciary and the Electoral Act, the National Assembly should strengthen that section to give it more flavor to assist the judiciary cure that mischief, as the case may be. Then INEC, when you sample opinion in the public, people have always canvassed the view that the burden of proof should also be shifted to INEC. The lead paper reviewer mentioned it. INEC should be able to participate, because when you look at Section 74 of the Electoral Act, we apply for certified true copy after the election and the result has been declared. You apply it to REC. REC has 14 days to issue it to you. And you have, under the Constitution, for 285, 21 days to present your petition, which start counting from the day the declaration is made. How do you get this result in a presidential election across 36 states? I participated in the last election. I went to Ebonyi State after meeting with the chairman. We are dispatched to get the result. I moved to Ebonyi State. I spent days in Ebonyi State. I don't want to talk about my experiences there, but it's prediction for another day. So that Section 174 too should be strengthened, should be reduced maybe to 7 days, as the case may be. So this is an issue that has to do with burden of proof. You can say we don't want Evidence Act to be applicable in Election Petition Tribunal. Like if National Industrial Court, Evidence Act does not apply in some proceedings there. Then the issue that has to do with the front-loading of witness statement on oath, it is quite impossible, practically impossible, for me as a petitioner in Presidential Election Petition Tribunal to drag my brother, my senior brother, the senior advocate, the director of legal, who's supposed to be a witness, supposed witness in my petition. How do I, with the police around him, or the next chairman police around him, how do I go to extract witness statement from him, from his office? It is practically impossible. Under the Federal High Court rules, under 3 of the rules or thereabout, he said, when you are front-loading all your, what you are required to file, your rejecting summons or writ of summons, he says, for witness statement on oath, for subpoena witnesses, the plaintiff is not required to file it. Because at that time, you are dealing with a known witness, you are dealing with somebody who is not willing to attend to you at that case. So there must be a way we can think of all this. For the MBA, the organizers of this program have done practically well.
I'll come back to you. Okay. So you still have the opportunity. Let's rest these, So I'm tempted to go to INEC, but I'll go to Barrister Dangana SAN first. There seems to be, consensus, that there is a lack of coherence in the electoral frameworks, contestations of the Electoral Act 2022 and the ground norm, the 1999 Constitution. We've also agreed that, okay, maybe the onus of proof, the threshold for the proof, should be lessened. The barrister has also now mentioned the use of the Evidence Act. But I want to ask you, what are the challenges? What are the constraints to forestalling these contradictory judgments? You know, in the exercise of their discretion, you know, how can we make, you know, the justices to see the law from the same point of view? You know, why would one judge see it this way and the other judge see it that way? So what can we do, you know, in that regards with the election petition?
Thank you, audience and PLAC, who have been lead educator or awareness forum when it comes to electoral matters in Nigeria. The issue of contradictory judgments or the issue of perception related to election largely depends on how educated our voters are. We are talking of judges who come from different backgrounds, and the law, why we have two sides of lawyers, is for everybody to give his interpretation on how it is being viewed. So it's left for the judges to agree on one of the position. However, we have seen a situation whereby in exercise of the discretion of this court or in viewing the perception of the law, they have consistently, with the greatest respect, tends to expand the frontiers of the law instead of espousing the law. And I will cite example. For instance, in 2012, in the case of Gundiri versus Inyaku, the issue of presenting witness statements in original language form was brought to bear. That since you made your deposition in Hausa, and what you are adopting in court now is in English, you must have brought that Hausa version for the purpose of comparison. It became hydra-headed. It didn't stop there. In 2019, in the case of Emir Abubakar versus INEC in Bauchi, the petitioners, armed with that provision of Gundiri versus Inyaku, filed the Hausa version of the statement alongside the petition. Now the goalpost was shifted, that the Hausa version was not commissioned by the staff of the registry. So we can see the inconsistency in respect of this. Secondly, with respect to issue of proof, in the case of GT Bank versus this man that has to do with evidence of payment of certification, it was at the court of at the Supreme Court. The Supreme Court said, go back to High Court, pay for the certification, then continue your case. But what happened in 2019 in Sokoto, where documents were certified, then a receipt was issued. The argument was that the date that the receipt was issued did not tally with the date that the certification was made. If these are not shifting the goalpost, what does it amount to? And these are things that give credence to the public perception negatively about how judgments are being handled. To the extent that you will be right to accord them with that privilege of saying that the election petition jurisprudence is fashioned in such a way that elections are not to be annulled. So, for whatever it is, we believe in the system. We don't want this negative perception to continue. If we only will adhere, the judges will adhere to the precedent, judicial precedents. The doctrine of judicial precedent is settle disputes once and for all. But because of the shifting position, the perception of the public, take it or leave it, will be justified in their own way. Except if the judicial officers and lawyers on the part that have benefited from it will see it in a different light. So, the provisions of the law are there to be followed. Talking about Section 137 of the Electoral Acts, with respect to issue of proof or calling supreme witnesses and what have you, the general perception or the general practice when it comes to filing of your case, either under originating summon, either under anything, is to the effect that, one, you will file the witness statement of the witnesses that you have control over them. If I need to apply for a subpoena to the tribunal to be able to compel an authority like INEC to come and testify, at that point I wouldn't have known who is the person that is coming. Not to talk of having an interaction with the person to file or to front-load his witness deposition. So, application of rules like this should have exceptions, just like they are clearly provided for in the High Court rules of the Federal High Court and the respective state High Courts. In 2015, my learned brother of the INEC will know that in Gombe, what happened was, a subpoena was issued by the petitioner to bring in the director of ICT. And she made a trip 3 times with serious objections. On the final analysis, she ended up establishing the fact that as at the time she came to present the petition, the cloud or the voters, the IRS, then it wasn't IRS, not IRS, the server is still synchronizing. So if the server is still synchronizing months after elections, is it the petitioner that you expect that at that point in time you would have made forecast into what is yet to be? So the facts of every case should be decided in the light of it, using the general perception or provision of the law without having to compel that it must comply to this at the point of filing the petition or not. By the time we are not to give room for dynamism in the jurisprudence of election petition, then we are in trouble. And the perception of the public will not change, one, about how INEC conducts their election, two, about cases, how cases are handled in the court and the judgment that comes out of the court. Thank you.
Thank you very much. Now, INEC, what statement, how does INEC view, this growing litigation about its elections? Is it, do you see as a statement of indictment? And Barrister Emokoro, SAN, reviewer, was of the opinion that INEC should not be mandatory respondents in election tribunals. Okay? How much does this litigation, this process, detract INEC? And what is your general opinion on electoral litigation?
Okay. INEC is the moving child. Let me quickly thank the organizers of this forum, because it has, I believe, afforded so many people to come and hear the issue of our electoral jurisprudence. Well, the issue of litigation does not distract INEC in any way. That's why we're there. And then if the numbers are such that we cannot handle, we'll hear. Nigeria operates a constitutional democracy. And in any constitutional democracy, issue of litigation is very, very much alive, so as to enhance the performance of each institution. See, my Lord Justice Ige has made it very clear, which the two speakers decided to sort of avoid discussing the issue. What did he say? Our election litigation has been classified as sui generis. And then it has been classified as sui generis. And this has been as long as far back as 1965 or 1960s. That has been the courts have been applying the precedents established times without number in the courts. So I don't see why we should differ from that. Now, let me take specific. My other brother here is the Ghana raised the issue of illiterate jurors. Made reference of Gundri and Inyalko and so many others. But what I know, what the court decided was that in any case where you have an illiterate, be it from any language of tribe of Nigeria, Yoruba, Igbo, Fulani, whatever, if he reduces his statement in his native language, the English translation shall accompany that statement to court. Otherwise, it is incompetent. I did a matter with a senior counsel who wrote a book on this particular aspect of illiterate jurors. And incidentally, he decided to ignore. And we use his book against him. It's very clear. In fact, my thinking is that, as my Lord said, once the political parties are organized, you don't need all those volumes of documents from INEC to prosecute your election petition. Because the law is that you get every copy of this material at every stage of electoral activity. And those documents are classified to be original, which you can use in proof of your petition. Now, what is missing is the fact that political parties are not such organized to make sure that there is a kind of reverse logistic between the political parties and their agents. So that if I send my agent to a particular polling unit, I make sure I get the result. As my Lord said, by the time agent returns all those results, your lawyers will have gone very far in assessing and analyzing those forms. But they don't have that. They wait days after, then they will now begin to send deluge of application to INEC for CTC of document. And one very important aspect is that the fact that these satisfied 2 copies of documents are not given as a matter of course. You have to pay. Many lawyers will just file the application for CTC and go away. They will not come for assessment. They will not pay for it. Until you pay for it, you are not entitled to it. So that's the issue involved. And then when we I look at the book through the book. Now, let's take the issue of jurisdiction. Is it not a kind of, let me not use the word, not to be harsh on my colleagues, but how can a lawyer file a matter before an election petition tribunal, which he knows that that court does not have jurisdiction, or the subject matter does not fall within the jurisdiction of election petition tribunal? What does that mean? Is it professional incompetence or what? And then the issue of when you file an election petition, you know what you require. You know the evidence. And as my Lord said, and quoting Justice Nikki Toby of blessed memory, he said that in an election petition, and indeed in any court process, the court does not look at what is discussed in the markets or at beer parlors. What the court concerns is what did the parties present to the court as issues between them for the court determination. So until when you are aware of what was the issue for determination between the parties, you couldn't say that the court has not done the right thing or any other thing now. So there are a lot of issues, as my Lord said, the political parties need to organize themselves to make sure that they have agents at every platform for election. And then our colleagues must make sure that they upgrade themselves with the current situation of the law. What does the court interpret the law? What do I need to prosecute a successful election petition? I can't just go and accept a brief. I know that I don't have the materials fact to prosecute. Then I will now, at the end of the day, I will now come and throw the blame on the court to say that no, it is the court that refused to do this, or this INEC that failed to give me the required document. No, you have the document, you are set. When you fail or you refuse to collect the document from an agent, then you have yourself to blame, not INEC. So, Let me see.
Thank you very much. Thank you. Honorable Battles, you are the closest to the political parties here. You are the most competent to speak for the political parties. I don't know if you went through litigation, but what we'd like to know is, the role of political parties in all of this. How well do they prepare, and what sort of support do they give their candidates? For the I know it's so exorbitant to collect forms for nomination now. Even the expression of interest is several millions, and then you buy the form. What support do political parties give to their candidates, through the process of election?
Thank you, and take you to PLAC. You said you don't know if I went through litigation. If you're conversant, you should know that if, because I'm from the home of peace and tourism, I wouldn't make peace to sit close to the justice from Court of Appeal because they removed me from office. I'm a victim of miscarriage of justice. A very big miscarriage of justice. In the sense that it's unfortunate that what happened in Plateau State, that the law was interpreted upside down, that it was the Supreme Court that vindicated us and hammered on the Court of Appeal that what they have caused in Plateau State will take many years for people to recover. Like me, the day my judgment was made, 2 people died of heart attack. And that's why I could still remember that. So, looking at what has happened, and it was, adding it with your question, what happened to me was a pre-election matter. But the appeal court gave judgment on pre-election matter that is post-election. So when you have situation like this and you try to look at what truly the justice system is here to give and align to what the parties, what they do before election. Yes, the parties has their own bylaws, how to get a form and so on and so forth. It's interesting that even in the Anambra primaries now, that PDP did not file in a candidate because of the cost of form. So, to me, that is an avenue that every party has its own bylaws. Some parties can make their forms free, some can have a fee to it, and so on. But it depends on the candidate and who his constituents or citizens trust in whatsoever party. And 2023 elections have proven that going forward in Nigeria is no longer about party, but it's about the candidate. So, mine is the pre-election issues that must have happened within political parties. And recently the Supreme Court have said that whatsoever happened within the political party is an internal affair. It's an internal affair. But what happened to us was an internal affair. We went through the process, we bought our forms, we did all that we could do. Yes, there was internal record, but we settled those issues. But it was the same issue that removed us from office as a post-election matter. And we've been trying to proffer solution at the National Assembly in the sense that why are we not taking technology seriously in terms of trying to even look at our cases? We've been talking about a burden of proof. If you, most of the civil societies that are here, there is no election they have monitored out of this country, especially in the West, that either is in the room or no polling unit, that there is no CCTV there. No polling unit that there is no CCTV. So why can't we put technology into our own electoral system that if we can provide, is it card reader? Why can't we provide a poll of CCTV in all our polling units? And that will take up, and that will address the issue of, is it proof of evidence or whatever the legal terms that you will. So, but we always make things so difficult at the end of the day. But for me and for my people, party is no longer an issue, but the candidate. But at the end of the day, let the court not determine who gets to office, because I believe from the ballot to the court, if the court don't understand, one day there will be the court of God.
Thank you very much. Now I'm going to go to my Lord now, just for 2 minutes before we go to our interactive section. I want you, sir, to directly respond to what the Honorable has said. Why do judges, entertain matters that they clearly do not have jurisdiction over? Pre-election matters are outside of the Election Petition Tribunals. Why would they entertain? And there are copious examples of this. So I don't know what your take is on that side. With his own.
Well, as far as Plateau is concerned, I will not delve into it at all. Yes. What I want to say with the greatest respect to all of us is that judges don't manufacture cases. It is lawyers and the public that bring cases to the court. When it comes to us, at the other side, we now raise objection and say, Your Lordship, you have no jurisdiction in this matter. And now, if we start from the tribunal, for example, if you take a pre-election matter to the tribunal and the other side raise objection and say the court has no jurisdiction, Section 285(8) of the Constitution says that courts don't decide it now. Wait, hear all parties so that they don't use this, their preliminary objection jurisdiction to disturb us from hearing the meat and substance of the real petition before us. The Constitution says, defer your ruling until the stage of judgment, final judgment in the matter. So if the courts, 3 of them, if they now get swayed by the argument that they have jurisdiction, and they decided that they have jurisdiction, yes, you can say they have had. That's why we have Court of Appeal and Supreme Court to right any wrong that may come out of such thing. Nobody is repository of knowledge. The judges, they are learned. But in the process of reading cases here and there, argument of counsel, looking at the processes before them. So it is not all the time that the court will say, I am right, I am wrong. That's why they go to appeal, which when they get there, the appeal may say, no, lower court, you are wrong. You don't have jurisdiction. And coming to issue of qualification, it is both pre-election matter and post-election matter. So there may be confusion in situation like that. For example, anybody who has no certificate, or he went and borrowed certificate of his brother and used it for election, and the brother now came and said, look, he did not even give me the money he promised me, I will surprise him. and they now sell the thing to the opponent. The opponent will use it as a veritable tool in the tribunal and say this man is not qualified to stand for election. And if the court in that situation, the Constitution gives them the power to entertain issue relating to qualification. So that is why I advocated during my valedictory in 2023 that Section 29 of the Electoral Act that allows somebody who had participated in primary and he lost to now wait for the party to send the name of the winner to INEC. He now goes and collected certified true copy of document sent to INEC. And he now started by saying, my colleague, the same political party that my colleague in the party had no certificate, he forged certificate and so on. If the matter is hard, both the candidate and the party will be disqualified. Look at section 29 or subsection 13. They will even be fined. They will have no candidate in that election. So why should you not use the provision of section 84:14 to challenge whether he has a certificate or not? So it's like giving dual opportunity to somebody who has lost election to now be tormenting the candidate of the party. I believe that such a person should even be sent out of the party, since it is their own internal affair. You have participated. So as far as I'm concerned, issue of conflicting decision may come in through such an avenue of qualification or no qualification. It can come in. But I'm not advocating for anything now. Like I said, I don't want to say anything about an issue in Plateau. But I want to say to all of us that most of the recondite areas that have been causing problems in electoral process have been resolved and settled by the Supreme Court. Perhaps what remains today is Section 137, whether they should be calling multitude of witnesses. But if you look at Section 137, like my brother rightly said, it has to do with breach, non-compliance of section of the law. It has nothing to do with proof of whether somebody has qualification or not. It has nothing to do with whether there is lawful vote or unlawful vote. It doesn't concern all of that. Perhaps it concerns Section 73 of the Electoral Act, which is a condition precedent that says before election starts, show everybody, record what you brought, ballot paper, this or that, all the documents that we use, you record them. And the law says if you fail to do that, then any election conducted will be null and void. I think that is the dissenting voice of my Lord in Baba Yusuf, my Lord Aji, that say, well, that very provision, if it is well explored, it is a condition precedent to voting, and you must comply with it. So as of today, there are so many areas that have been settled in electoral matter. Issue of language in which you present your witness statement on oath is no longer an issue. Then my other brother there, you mentioned Federal High Court rules. It has no application. It is only where there is lacuna in the Electoral Act that the Federal High Court rules will be applicable. Otherwise, enough provision has been made in paragraph 4, first schedule. And if you look at paragraph 4.5, it talks of all witnesses to be called by somebody. How can you say because you want to call INEC? Don't you know those who are in INEC? If you want to call them for God's sake. So that is what all these things are for. And that is why we say election petition is not like a civil matter. It's not like a civil matter at all. It's on a special class of its own. If we don't want it again, then go back to National Assembly. All the laws that have been causing problems in electoral process were made by the National Assembly. And kudos to the judiciary for always bringing it out and for always enabling the National Assembly to correct themselves. Thank you.
Thank you very much, sir. Thank you. We're going to our interactive section now. By reason of time, we cannot take more than 4 questions. And please, I want to ask us to please be brief and go straight to the question, not another commentary. And please, let's get your name for the rapporteurs, your name and your affiliation very, very clearly. Thank you very much. Yeah, we're going to take J.K. Pele, and then we'll take Professor Samegu, we'll take the brother behind him, and then the other one. So J.K. Pele is 1, Professor Ego is 2, the gentleman is 3, and the other gentleman in white is 4.
Thank you. So now that you've called my name, I don't need to introduce myself. I don't think I need to introduce myself. I just wanted to ask, in all of the conversation and very good interventions that have been made, where is the place of women, youth, and persons with disability? Are we not part of the court system? Have we been sent to the back side of the court? What is happening, present and the future? Thank you.
Was the second hand, Professor Sam Egusa.
Thank you, moderator. I'm not a lawyer, so pardon me if I goof.
Hello.
My question is very simple. Festus has been telling me, and the retired justice of the appeal court has repeated it, that election petitions or cases or matters are sui generis. So, at what point does Evidence Act become important? You know, so is there no conflict between the reality that they are in a class of their own, and then when it matters most, we jump back to Evidence Act? You know, is this my illiteracy that is a problem?
Probably.
My name is Idris Miliki Abdul. I'm an election observer. I live inside Nigeria in Lokoja. My concern is that for a political party that failed to have agent at the political party, what is the offense? And if you don't have now, what should be the offense? When somebody is contesting the election, they are creating more problem for us. We have always been at the polling unit, and we can see, we have even advocated to INEC that party agents will have identity with their passport. We observers always have tag with our passport. They don't have. And if we are next say that a presidential election have no agent in 3,000 polling units in Nigeria, what is he going to present at the election tribunal? That is the question my concern is.
Thank you very much. Good question.
Yeah, I am there.
Good afternoon. My name is Abdulhakeem Ago. I am the Assistant National Legal Advisor of the People Redemption Party, PLP, and I'm representing the chairman of the party here. So, briefly, before I would like to quickly mention something which you raised now. It's important to us because it actually affected us in the just concluded gubernatorial election in Ondo State, which is the issue of filling of polling unit agents. And as far as this is concerned, for example, in the just concluded Ondo State governorship election, INEC used their platform for the filling of polling unit agents. Unfortunately, they stipulated some time for the filling of polling unit agents, but before the end of the day, I think few days to the time stipulated, so this website was not going through again. We could not upload our polling unit agents. Eventually, we had none. So now, in like 80% of the polling units areas, we do not have polling unit agents, and the election was conducted. Now relating to his question, Would that deprive us? Now, we went to Federal High Court, we did a lot of things just to ensure that we were able to do this. We could not succeed. Now, in the event that people eventually vote for us, because we don't have polling unit agents, should that deprive us from actually contesting the election petition? I don't think that should be. Now, I'm now going to my own question now, which is the issue of yes, which is, I'm so sorry, please, which is the issue of electronic transmission of results. I think this should be the major issue here now, especially as we go to section 137 of the Electoral Act, which surface the burden of proof. So if there is a mandatory transmission of results and the IRF is made part of the collation process, so in that situation, what we have like a CAC, where once you fill in your everything on the CAC portal, anytime anybody from anywhere can actually apply to the CAC and generate automatic certified two-copy document. So in this situation, we can just have things like that, where polling unit results that are transmitted or IRF be automatically certified, so that when parties approach the court, they can download this, and since it is certified, it is a public document to be admissible automatically by the court, and the court can actually base its judgment on that.
Thank you. Well, that is more like a question, but I don't think so. Sir, I've been asked to give you an opportunity to quickly ask your question.
Thank you. My question goes to, my name is Meka Ononamadu. I'm from Imo State. And you know the history of Imo State when it comes to court judgments. And that is what we are still suffering till today. The issue of inconsistencies in judgments. And I'm using that of Imo State as a case study. A policeman brought documents that he collected. He was not an eyewitness. And the final court, which is the Supreme Court, robbed the entire voters of Imo State of that their mandate and gave it out. And as a court of final judgment, there's nothing else they could do than to face the consequences.
Sorry, what's the connection?
The question we are asking now, in the case where somebody who was right faced that kind of judgment, what type of thing can we do to get remedy? What amendments will be required now so that we don't leave our destiny into this course of fire?
I think you need to fill in the gaps. Yes. The policeman collected the evidence, he was not an eyewitness.
Yes.
So what happened?
And then the court accepted that evidence and used it as the basis of judgment.
Okay.
Which
Thank
is
you very
what
much.
we're suffering from. And that is where the basis of inconsistencies. But in other cases, they will require you to bring the eyewitnesses.
Thank you very much. The question is clear now.
All right. Somebody is asking, where is the policeman now? He must have retired and left and jackpot.
Andy,
because someone will take care of him.
We'll take the gentleman, Andy, and then finally we'll take NLB.
Okay.
Yeah.
Thank you. I'm Judah from Development Dynamics. My question is to all the legal minds there. Just to note, sir, you know, the economy, we are dealing with a social economy. And it does appear that we have this huge subsidy economy. Then over time, since we started this our civilian experiment in 1999, we seem to have developed a huge election litigation economy, which is possibly, with the removal of subsidy, it is possibly the biggest economy at the moment, sub-economy in this country. And I'm worried really, because of the amount of funds involved and the interest entrapped. I'm worried whether there is any incentives to make things better. Because if it becomes the pathway to being some of the most powerful lawyers in the land, then it is something that we need to think about. Is there really any incentive within the legal system to improve on elections and take it out of our courts? Because the amount of time our judges spend on elections as against other core issues that can move the economy forward is a big issue for me. I want to know what the lawyers think about this. Thank you.
Thank you very much. Sorry, please. Madam Eniobi. Oh, you're from Imo State.
I'm from Benue and Anambra. I want to say a big thank you to the panelists and well done. I just want to say that in the context of election, this is from the ballots, from ballot to the courts. We have to realize the brutalization of the courts itself. Because it's not supposed to be from the ballot to the courts. The declaration of elections should be done by INEC. Because when you are budgeting for elections, you don't budget for the judiciary. You budget for INEC. And why is INEC not declaring the results? And now, it's like the political class. What we have done now is everybody to the court. How many courts do we have in Nigeria? And so this is very, very important. We are talking of the soul of Nigeria here. During the elections, when the injustices happen, many people die. And so we worked, from the civil society angle, we do a lot in trying to observe and trying to work with INEC and work with those who are concerned to make sure that reality on ground, because you go to the court of public opinion, you say, why are they saying this or why are they saying that? When they talk about provision of evidence, the case of Kogi in 2023, the last election, the case of Kogi, they provided even the beavers and everything. About 500 beavers were presented. We had the registered voters, or those who were supposed to vote, registered to vote, were not up to 300,000. But an election was declared and upheld by the Supreme Court. Is it the Supreme Court or the Appeal Court now? Both. That somebody was declared a winner with over 400,000, in terms of voting. When did we go? That one they provided all the evidence. We need to think of patriotism. We need to think of social justice. We have seen elections where people did not contest election and they are the winners. That's the case of Imo as well, that somebody number 4 was declared the winner. I think NDA has a lot of work to do. The judiciary has a lot of work to do because Nigeria is depending on you. The soul of Nigeria is depending on you. And so while you are talking of evidence, many people are dying because we don't want things to be changed by force. We don't want, the struggle to go to the street before we start deciding what to decide. I know that the burden of the election is now going to the judiciary instead of INEC. But if INEC does not qualify to organize elections, then we have to look at other things. Somebody mentioned the issue of the beavers or the electronic systems. We talked about the beavers and glitches and all of that we're talking about. We said within 21 days, after the declaration of the result and all of that, there is the need to prove that. When people cannot bring their evidence together because INEC will tell you to go today, come tomorrow and all of that, and the time passes, who bears the burden? I want us to know that women are suffering, what things are happening. In the case of Atiku and the Yaradua case, I want to mention it here. That was a very interesting judgment. The whole Nigerians watched, and the judges, we had 3 against 4. And that was how it was decided. Even the president then, because you have to have the political will, the willingness of the ruling class to say justice should rule, or the rule of law, respect for the rule of law. Where are we going? We need to discuss the soul of Nigeria.
Thank you very much.
Patriotism is the key.
Thank you very much.
Thank you very much. Yes.
So our panelists, you've had the questions. We will respond to the ones that are relevant to us, and then we will have a minute each to discuss.
That came from our people. You leave those ones.
Correct. So maybe I will start with my MBA president. Just 1 minute, because of our time.
On a lighter mode, just to my lord, when I mentioned the Federal High Court rules, I I was not saying that the Federal High Court applies to Election Petition Tribunal. I was also referencing Order 2 of the Federal High Court rules, which say what you have to front load when you are filing matter at the Federal High Court. And that Order 2 says that in filing that, the plaintiff is not required to file witness made on oath of a subpoenaed witness at that point. So that I'm recommending that why I mentioned it, that I'm referring that such should be included in the Electoral Act, so that we specifically stated in the paragraph that the petitioner is not required to front load the witness made on oath of a subpoenaed witness. That's my recommendation. So going by your question on the issue of Evidence Act, it still goes to strengthen what we have said before, that Evidence Act clearly should be jettisoned in Election Petition Tribunal. It's constituted to be a clock in the wheel of administration of justice. Whether we take it or we leave it, but the reality, the practicability is there. There's no way we can prosecute cases at the tribunal with reference to burden of proof, invocation of section 131, 132, 1233, 135 of the Evidence Act. It's not possible. And the requirement of calling witnesses across the polling unit to prove of a voting on substantial or non-compliance, as the case may be. So the Electoral Act has to be amended, further amended, to be able to carry out the expectation. It's an evolving democratic process, and we believe, as MBA, as lawyers, that some of these things will be taken care of if we are serious, and National Assembly will be able to take this seriously. Because sometimes some persons will have to, well, our elections are coming, we need to protect our office too. Sometimes we don't make laws that hold us here. So on issue of section 60, sub 5 and 64 of the Electoral Act, 60 sub 5 just said that presiding officer shall transfer the result in a form prescribed by INEC. It is loose, it is roomy, it is amorphous. It needs to be amended such as to tie what should be transferred and what should not be transferred. And there should be a time frame within which such results should be transferred. Now, when you look at sections 64 too, as the case may be, what is issue that has to do with technical glitches? Like my friend rightly pointed out, what is technical glitches? Either there was a thunderstorm and the server was affected, or there was a human intervention, somebody went and switched off. These are issues that has to be amended in the Electoral Act, specifically stated, so as to assist the court. Because why the court now look at evidence like this one? Because the Electoral Act is not too clear on some issues. Let IREV be specified in the Electoral Act, not in the guideline and manual of INEC. Let BVAS be specifically provided in the Electoral Act under section 64. Say it is mandatory for a result to be uploaded through IREV at the polling level, and any result that does not come to the IREV through the polling unit will not be reckoned with in the computation.
Thank you.
So as to guard against some of these things. So for MBA, it's an evolving process, and MBA will definitely be part of the process and will always assist in whatever will make our democracy and constitutional work. Thank you.
Thanks a lot. You can pass the mic.
Okay. It's okay. Gentlemen, on a very serious note, we are here for a very serious business. And our reactions have shown that there are certain things that are being trivialized. Much as we can criticize, but let's be serious about certain issues. I will not subscribe to a situation whereby the role of declaration of an election is being arrogated to the court. Why did you go to the court if INEC did not make declaration in the first place? It is after INEC made declaration, you are not satisfied with it, that you are going to the court. And you are going to the court because both the Constitution and the Electoral Act vest the jurisdiction to make pronouncement on the court. We should not just, for the purpose of making criticism, make ourselves a laughing stock and inclusive of the system. We need to have a strong system. We are here to discuss on how the system can be reinforced and made very strong to that effect. Still, discussing on issue of jurisdictions of the courts. there cannot be limits to what the courts can do. It is common, during the review, it was stated that where allegation of crime is made in an election petition, the standard of proof is beyond reasonable doubt. Unfortunately, in even attempts to prove some of this, you see the courts declining jurisdiction. I'll cite an example. In 2023 election, in one of the states, where the person who was declared the governor was convicted, the same court that convicted him, being a magistrate court, was said to have set aside that conviction to pave way for the swearing in. The courts are now being used as an instrument to clothe immunity and jurisdiction. This matter were presented before the tribunal, and these are allegations of crime. If the standard of proof is beyond reasonable doubt, should the tribunal not entertain it and decide one way or the other? It traveled all the way to the Supreme Court. Supreme Court said, withdraw the appeal. So these are some of these perceptions that weakens the confidence that normal individual citizens have on the system. We've had also a situation whereby convicts was sworn in the front of the prison because the court that convicted him gave him bail pending appeal. Until today, that appeal is not heard. Till today, the appeal is not heard. So, these are incidents that we need to see how we strengthen the situation and our systems. A brother here made mention of issue of party agents. Yes, your system is synonymous to what occurred in Imo. There are different ways that you get reports. Where a witness is subpoenaed, look at it like in the Imo case. For every unit, you have security agents are entitled to be given copies of this report. And the results were collected by the Assistant Commissioner of Police or Deputy Commissioner of Police who was appealed and say, okay, you bring your results. And this is the result. What stopped the court from using it? So there are instances that much as we want to criticize the system, you just cannot help but accept the role. And if not for the intervention of the courts in some of these instances, particularly like in the Imo, there wouldn't have been governance. So let's ask those that participated in some of these petitions. Because things are flittering on the air, on the social media and what have you, it does not become a basis for us to pick it and condemn the judiciary. So your agents, most parties submit the name of agents, and in truth, they don't have money to give allowance or the lunch for the agents during the conduct of the election. As such, they will not turn out. So let's educate our members to be committed to the ideals of the party instead of heaping the blame on INEC that they either did not give you document or some other things. This is a holistic approach. Voters education, parties education, agent education, pre-election is very vital to the success of any election that is to be conducted in this country. Thank you very much.
Well, I think the issue of party agents, somebody asked what happened to political parties that they don't have agents at the polling units. But I think nothing happened to them. It is their right. If they decide to forgo their right, so be it. But then what I do now that INEC is taking steps to make sure that not only that political parties have agents, but the agents are coded. Each particular agent has his number, because most often than not, you go to the court, you see party trying to bring different person who acted as agent for the purposes of all this election litigation or whatever. INEC is now taking steps to make sure that all agent is coded and he has a particular number, so that when he goes to court, we identify that agent with that particular number. And then the issue of IREF. We should understand that IREF is not a coalition center. It's not a coalition platform. You see, we almost get it wrong when we are taking that IRF and whatever. And we should know that collation of result or conduct of election from the polling unit up to the last place of declaration is guided by the law. The law spells out what should be done. So you cannot just bring something outside the law and say this must apply and whatever. So we should understand that. But then if the National Assembly, the wisdom, feels that IRF and all those should become part of the coalition platform, so be it. But at the moment, it's not the law, and the court has so declared as such. They are not platform or coalition of election results. It's only views and that. But what people don't even forget, I don't normally forget, is the fact that if a presiding officer declares his course in a particular polling unit, he moves to the next coalition platform. And there's a tendency that that one may be cancelled at that platform. And already that one must have been uploaded to the RF. Unknown to the public, that one will have been cancelled, but you see people referring to that particular result. So there are a lot of issues on the issue of RF. And now, I think the issue of IMO, election in the IMO and the declaration of governorship election in the IMO, I think people should do a lot of good to themselves if they read the records of that process. Because there are a lot of misconceptions about the public perception about the decision of IMO, governorship election in IMO state. People should read the record and see what actually happened. You know, I will say no more about this.
Well, with all the perception, even from our discussion here, it has shown how Nigerians are still confused on some of the justice systems that have been given out. And from the National Assembly, we make the laws, and at the same time, how the laws are being interpreted is it's a very big issue. And PLAC and even most of the civil society that I hear, it clearly shows that we have a lot of work to do, a lot of sensitization to do. Because if we concentrate on just looking at the justice system without morality, then everybody will want to bring out, give out judgment according to the way he understands the law. So we really we have a lot of work to do, because the issue of perception, the issue of what we need to do as a people, it's a very, very big issue. Because you all agree with me that even all of us here, we have not yet even agreed on one single issue, because everybody is still defending where he comes from. So more and more work needs to be done. For me, a better Nigeria is what I'm looking up to. But as long as we don't look at morality, we don't look at justice and fairness, we will still be where we are today. Thank you.
Thank you.
Well, thank you very much. I think a lot of the issues raised have been addressed. But people with disability, all I wish to say is that under the Constitution of the Federal Republic of Nigeria, we are all one. So your disability should not deny you the right to participate in electoral process or in democracy. And many conferences relating to election, I've been seeing people with disabilities being given one role or the other. So perhaps what you still need to do is to approach the appropriate authority to give you more opportunity to perform. But as it is also, there are so many people with disabilities in government, all arms of government, working diligently. And many of them are even better than those who have no disability. So that is what I can say concerning that one. Then these ballots, from ballot to the court, we need to understand it. It's not that immediately they finish balloting, or so then they enter the court. No, with greatest respect. I think what the organizers are saying is that after election at the polling unit, after declaration of result by INEC, the next place is the court. And like my brother Danganai said, without result by INEC under the law, the court has no jurisdiction to entertain any election petition or what have you. So there must be a result that is declared. And that's why Section 2285 said that after declaration of the result. So that one is very clear. Then political agent that has been well flogged.
Punishment side, you don't.
No, right now there is no punishment. It's your choice. If you like, send the polling agents to polling booths. That's why I say, as you make your bed, so you will lie on it. All it will mean is that you will not have evidence to prove what happened in particular polling unit, and that will be to your own detriment. It's as simple as that. Then issue of forms and so on. You cannot get automatic certification just from the air. You need to apply for certification of document and be given by INEC. Whether photocopy or whatever, it has to be formally certified by INEC, and you must pay for it. Then taking election out of court. Well, the court is not clamoring for election matters. On the contrary, it's even interfering with other jobs of the court. So, but because the Constitution has placed that burden on the court, that is why the court must intervene. The court did not appoint itself. It is the Constitution that gives jurisdiction to the court, limited jurisdiction to the court to entertain election matters. And the court does not elect candidates for the parties, and the court does not elect anybody for the parties or the public. It is decided upon the evidence brought before the court. Then ballots to the court without result. You have answered this one. So perhaps I should leave you with one matter. Whether it will not be in the interest of the nation to refer back to what happened in 1983 or 82, when we have only 5 political parties, in order to solidify our democracy, enhance unity among the people, particularly the politicians. Because when we have 5 political parties, it appears things were better than this. But some political parties today, if you look at it, you know the type of parties some of them are. But all I am saying with the greatest respect, and my own personal view, is that political parties in the country, just like we have under the military, should not be more than 5 political parties, so that it could be well managed in the interest of all concerned. And I wish to say all the views I've expressed here are personal to me. It is not the view of the President of the Court of Appeal.
Thank you, sir.
So thank you very, very much. Let me, on behalf of PLAC, thank our eminent panelists for your very quality interventions and your time. Thank you so very much. It was a very rich and very stimulating discussion. I also want to thank our audience, for your rapt attention and for your contributions. Thank you very much. Finish.
Thank you. Please put your hands together for them, please. Let me ask Mr. Clement Wankwa to please join them for photographs. Perhaps a book if you want to. Let's have you with a panel. Just take a photograph. The question begging for answers are quite many, but the very one that is bothering my mind is that of Plato. If the Supreme Court could say that the appeal court was wrong with a decision they took about Plato and asked the governor to remain as governor, why did they not say that all the lawyers the lawmakers that were sacked should also be returned? Why didn't they do that? Well, that's a question for another day. We'd like to thank you very much. Let's take this photograph and please let's applaud our panelist and the moderator. Thank you very much. Mr. Clement Wanku, by the way, we'd like to thank you for the yeoman's job you're doing. Thank you. We appreciate you and your team. All right. It's here, sir. All right. Are we done with the photographs? Photographer? Okay. Please, pictures is still on. If we have different photographers, let's get a bit up close so that we can. Yes, please. The vote of thanks. Okay, Kiro, please join them. You've been doing very well. Yeah, for these pictures. Yeah. We like women. Yes.
Women are not on the panel.
Well, we have a woman here. Mrs. Ogaku, please join us. And then, Mrs. Ogaku, please join us. Kindly. We also recognize the presence of the former DG Voice of Nigeria. We'd like to welcome you. Thank you very much. Yes, please, madam. Let's shift a bit so that she can find a space there. We can widen up a bit. Just widen the space so that photographer, I'm sure you've got a lens that can capture all of these persons that are here. Thank you very much. Please take your seats and then we'll be winding down very shortly. Please, as we wind down, the Programs Manager, Legislative Issues of PLAC, Nkiru Uzodi, will be moving the vote of thanks. Thank you very much. Please, a warm round of applause for her.
Thank you very much, Mr. Andy, for your wonderful moderation of this event. Thank you very much, sir. Good afternoon, everyone. On behalf of Policy and Legal Advocacy Center, I would like to express my heartfelt gratitude to each and every one of you for being here today to witness the launch of our report from Ballot to the courts. This is a very important milestone for PLAC, and we are truly honored to have you join us to celebrate this achievement. First and foremost, I would like to extend our sincere thanks to the European Union for their support, without which this project would not have been possible. The EU's commitment to this initiative strengthens our shared vision to improve democratic governance in Nigeria. I thank our distinguished guest speaker, our lead discussant, our panelists. Thank you very much for your invaluable presence and your insightful contributions. We are grateful for the time and effort you dedicated to making this event special. I would like to express our deepest appreciation to the team behind this report, my team at PLAC. Mr. Okapu, our legal analyst, we have some of them here. I can see Adobe, Okiro, and MM. I would like to mention that every chapter, every data point, and every insight in this report was meticulously researched and presented And we are incredibly proud of the collective effort that has gone into bringing this report to life. If you look at the publication, you see 2 flyers. It's very important to mention that we developed 3 outputs, 3 very impactful resources for analysis. This report is one of it. The second is our online case directory. So there's this flyer in the book. So you can just scan it with your queue directly to the website where we have archived over 1,500 judgments. These judgments, each and every one of these judgments was summarized with decision indicated. The certified true copies of these judgments are also uploaded. And then the third output is our Electoral Act app, which we launched in 2022. This app contains explanatory notes, and it also contains relevant case law. So we have updated it with recent decisions from the 2023 election petition cycle. So this is just to show you the magnitude and the extent of work that went into this. So thank you very much to our team, our legal analysts, and our team in-house. Because without your dedication, hard work, and support, this book wouldn't have been possible. We also like to thank our partners at the Court of Appeal who facilitated access to the court records, to our audience and distinguished guests from the media and civil society, our EU SDGM partner, TAF Africa, IPC, CIMESO, Yaga Africa, KUKA Center, Nigerian Women Trust Fund. Thank you so much for your participation and for being part of this launch. As we conclude these events, we're excited for the future, for the discussions and hopefully the reforms that this report will generate. Let us all continue to work together to drive progress and make a lasting impact in our field. On behalf of PLAC, thank you all once again for being here today. We appreciate your support and we wish you a safe return to your various destinations. Thank you. Thank you. Sorry, just housekeeping announcements. For your parking tickets, you can take it to the check-in counter and they will validate it so that you can exit without paying. So you can just tell them you attended this event. And then we have reimbursements, so you can please meet our staff at the registration desk. Thank you very much.
Does this reimbursement include me? Yes. Thank you very much. Please, ladies and gentlemen, we've come very close to the end of this event. Close because we must take the national anthem. But please, as we part ways, let us not see this at the end as the end of a conversation, but rather the beginning of a renewed commitment. The future of our democracy depends on the actions we take now, the voices we raise and the principles we uphold. Safe travels from me and the organizers. My name is Andy Gabriel. We wish you a very pleasant day ahead. Please, let's rise for the national anthem. The national anthem, please. Nigeria, we hail thee. It's still our national anthem.
Sovereign motherland, our flag shall be a symbol that truth and justice reign in peaceful battle ordered, and this we count as gain. To hand unto our children a banner without stain.
you all so much and do have yourselves a lovely day. And for those of you traveling, safe travels. God bless.
Please, there's lunch at the cooker. If you don't have a ticket, please meet one of the ladies at the registration desk. Thank you.